15 seconds, 10 seconds, 5 seconds. Now, in the present case, during the course of counting, an application was made to the Election Commission of India wherein it has been stated that there was difference in signature of the presiding officer on the ballot papers. It was alleged that the candidate of Rashtriya Janata Dal had received 99% of the votes. In respect of another two booths, there was another application, although the same could not be produced in original, but there was allegation that there were irregularities in the signature of the presiding officer of booth number 22. He filed another application for recounting before the Chief Election Commissioner, New Delhi, wherein grounds raised that the appellant lost the election by a margin of 265 votes, whereas number of votes rejected were 2000 and several votes were wrongly declared invalid. It was also alleged that there was irregularities in the signature of the presiding officers of booth number 2 to 5. But the learned judge found that a new case was sought to be developed, that huge number of ballot papers of booth number 225 did not even bear the signatures of the presiding officers, and there was no distinguishing marks of the booths itself, which was not the case when they filed the petition before the returning officer or the Election Commission of India. The learned single judge, after examining the matter, found that the ground which was raised before the Election Commission of India and the ground which were raised by the appellant for recounting before the returning officer were different. But after going through the matter, he observed that the petition, in order to substantiate the case for recount, has to make a definite case with a specific allegation before the returning officer. He found that grounds sought to be raised before the returning officer and before the Election Commission were at variance. He further observed that if at the time of the counting the election agent raised objection and no good reasons were given by the returning officer for rejection, then that could make out a case for recounting under section 63 of the Act. But no such case was made out. Similarly, learned judge found that allegations during the trial also were not substantiated by oral and documentary evidence. It was also alleged that there was a difference in signature of the returning officer in the ballots. Subsequently, the case put up that the ballots did not bear the signature of the presiding officer at all, and there was no distinguishing marks of the booths in the ballots. Learned single judge found that the attempt was made to improve the case from stage to stage. Therefore, allegations lack bona fide and makes it doubtful. Learned single judge has also found that allegations of missing ballots and double marking brought out in the election petition, but no case evidence was laid in support of the allegations. Stop. Over.